Let's discuss this further now with defense and trial attorney Misty Marris. Misty, obviously this is something that activists are going to try to take to the ballot. So we will see where that will go. But in the interim, what you are going to see, it appears after 2 weeks here, is no more abortions, with only an exception for the life of a mother in Arizona. Talk to us a little bit about what that is going to look like, considering there has been a lot of confusion around that. It seems clear on paper, the life of the mother. It's not so clear. We know that in other states, it has actually cost some women who had wanted pregnancies the possibility of being able to have future pregnancies.
Absolutely. So first of all, I'm sitting here trying to figure out how a court found that an 1864 law supersedes a 2022 law regarding abortion. But I've read, reading through the decision, and I've read the court's rationale. But to flip to what you're speaking about, 14 days for complete upheaval of the medical industry, of any woman who is having any kind of treatment or was seeking treatment, that's not too much time. And to your point about what does it mean to save the life of a mother, you nailed it. It has not been clear what that means from the legal perspective, as there's been confusion between which law applies in the state of Arizona, which was the precipice for this case. The question is, what is a life-saving measure? How far does that have to be? Is it truly that someone is at death's door, or is it a condition that could impact the mother's life that qualifies under the statute? So all of that has to be hashed out. As far as what happens immediately, the governor had actually gotten ahead of this, and there is an executive order that says that the attorney general is responsible for enforcing this statute, for enforcing this decision. And the attorney general has said, and I imagine we're going to hear from that today, that they're not going to move forward with enforcement. Now, that leads to a lot of other legal issues and challenges from local prosecutors. So this is a thorny road ahead with a lot more legal issues that are going to come.
Yeah, you can bet that there's already a lawsuit being crafted against the attorney general for the claim that they won't enforce this. Misty, I want to dissect the rationale here as you were describing it for this decision. The Supreme Court of the state of Arizona apparently is saying that they are constitutionally obligated to go by the legislature's judgment, which is accountable to, in their words, the will of citizens. They're effectively arguing, and I quote, that to date, our legislature has never affirmatively created a right to or independently authorized elective abortion. Essentially, what they're saying is that the legislature has never enshrined abortion as a right in the state constitution, and therefore they have to revert to what's on the books. And what's on the books is this 120-plus-year-old law. Is that basically what they're saying?
Yeah, let's take it step by step. So here's what happened. In 2022, there was a law passed in Arizona relating to a 15-week gestational period, so a 15-week ban. Obviously, that is a more expansive right than this 1864 law, which says abortions are essentially illegal with the exception of when the mother's life is at stake. Because that 2022 law was predicated on Roe v. Wade, the right to an abortion was predicated on Roe v. Wade, and therefore the 2022 law stood. Without Roe v. Wade, there is no independent right either in the state of Arizona or in or the federal law that would serve as the basis for what Arizona did in 2022. Therefore, it's gone. And so the 1864 law, which was always on the books but was essentially just inactive and stayed because Roe v. Wade provided that right constitutionally, is now in effect, and that there's nothing on the books in Arizona or the federal law that says it couldn't be in effect. There's nothing to negate it. And so since it existed, it's simply back into effect at this point. So that is the logic of the court. And that's why they say it supersedes what they did in 2022 as a state, which to me sounded like 2022. Well, that would be the will of the people. But because that was contingent on Roe v. Wade, they said, nope, back to 1864.
Very interesting and clear. Thank you, Misty, for that. If you could stand by for us, because actually Governor Katie Hobbs in Arizona, they're just reacting to this ruling. Let's listen to what she said.
We don't need to call a special session. The legislature's in session right now, and they can do this right now. They can do it today, and they should. They should listen to their constituents, 9 out of 10 Arizonans who support access to abortion, and do the right thing so that we are not living under the confusion and chaos and lack of access to health care that's needed. As you heard from those two stories, they can do it right now.
Right there.
All right, there you hear it. Governor Hobbs saying they don't need to call a special session. The legislature is already in session and could clear this up, but obviously that is very much in question. Misty Marris, thank you so much for being with us. Obviously, a lot of breaking news here today as the Arizona Supreme Court has said that the state has to go all the way back to this law, 123 years old, but actually even older in its original formation, all the way back to the Civil War.